My name is Andrew Van Arsdale, and I'm one of your lawyers representing you in your case against the Boy Scouts of America. As you've recently heard, there is a revised plan of reorganization that has been sent out to vote. A couple important details of this plan of reorganization are what I want to discuss today. This revised plan has a couple important elements that I want to discuss today. The first is this carve-out that you've heard a lot about. The idea is if there is a case in statute that we can prove notice to the BSA or a sponsoring organization with liability, that case can be opted out into a pseudo-litigation or arbitration type format. The case would continue to go through the bankruptcy, but if successful in an ultimate recovery, 20% of that recovery would flow back down to the trust. Now keep in mind the trust, as it would exist under this plan, is already funded to the point of $2.7 billion. That $2.7 billion is made up of contributions from the Hartford Insurance Company, Century Insurance, the Boy Scouts of America National Organization, the local councils, Zurich Insurance Company, and the LDS Church, or the Church of Jesus Christ of Latter-day Saints. In addition to these individual companies that have already settled, there are 15 insurance carriers that have not. There are also numerous sponsoring organizations that have not contributed to this trust. The idea of this opt-out or carve-out section of this revised plan would allow these cases to go forward against these entities and, in theory, hold them accountable for billions of dollars in liability that would flow back to those individual claimants, as well as a percentage of their recovery back to the trust that would benefit everybody that filed an individual proof of claim form. Another important part of the revised plan of reorganization that has been filed and that will go out for a plan confirmation hearing starting on Monday, March 9th, is the idea that if the plan is confirmed by Judge Silverstein, upon trust formation, the trust will be funded to the tune of $500 million. This trust is funded even while any appeal would be going on to the district court challenging the legitimacy of the plan confirmation. This is important because for the first time ever, if the plan is confirmed, money will start coming out of the Century Insurance Company, of Hartford Insurance Company, of the local councils, and it will go to a trust to pay you money damages through the TDP for what you went through. I know this has been a very long road. We just passed the 2-year mark since the BSA filed bankruptcy. In my count, this is maybe the 6th or 7th amended plan that is put forward and tried to be explained to you by myself and the other lawyers working on your case. But I do think we are finally at a point that we have a plan in front of us that may just work to get your case resolved. As you have heard, the TCC, or the Torts Claimants Committee, has now revised the recommendation on this plan and encouraging people to accept the plan rather than reject the plan. In addition, the majority of other law firms that were going to advise their clients to reject the old version of the plan and file objections to it have now reversed course. They're encouraging their clients to accept the plan. They're no longer objecting to this revised plan of reorganization and in fact supporting it. So what does this mean? It means there is now almost universal support from the various plaintiff groups that represent abuse survivors to support this plan and encourage Judge Silverstein to confirm the plan. If the plan is confirmed, a trust will be formed and we should likely see money damages being paid out by the end of this year. The court has extended the voting period through Monday, March 7th, with all ballots due back by 4 p.m. Eastern Time. If you would like a new ballot to revote and you have not yet received one, please contact my office by emailing me directly at andrew@avalaw.com or calling us at 1-800-777-4141. We will be sending the ballots through our own individual case file system and not using eBallot this time around. If you have any questions after you get the ballot, simply call us at 800-777-4141. As you may recall, the original vote on the plan of reorganization that you voted on towards the end of last year came down to 73% accepting the plan and 27% rejecting the plan. With the endorsement of the Torts Claimants Committee, the various state court lawyers that were opposed to the plan, we expect that those numbers for accepting will increase significantly. Omni has been ordered by the court to produce the total vote count by Thursday, March 10th, And we'll know going to plan confirmation on Monday, March 14th, what the new vote count is on accept or reject. Here at AVA Law Group, we've been very hesitant on telling you how to vote, whether to accept or reject this plan of reorganization. But I will tell you, based on what I understand about this plan, this may be our best opportunity to both hold the BSA accountable and recover money damages for what you went through for the abuse you suffered as a minor child in the Boy Scouts. Again, my name is Andrew Van Arsdale. If you have any questions, please email me directly at andrew@avalaw.com or call our offices at 1-800-777-4141. We will have another update out after Omni releases the data on the new vote count in terms of accept and reject, along with any other information that we need to provide to you going into plan confirmation the following week. The plan confirmation hearing is a public trial. It's going to last 2 to 3 weeks. It will be conducted virtually through Zoom. If you want to watch all of it, or part of it, or none of it, that's totally up to you. But in our next update, we'll have additional information out about the best way to do that, to register with the court, and to watch this plan confirmation hearing if you so desire. Thank you again for taking the time to watch this video. If you ever have any questions, just give us a call.